increasingly we're in a situation where we're dividing ourselves, and people are driving wedges between suburban and urban and rural communities. And we really believe that our economy works best when all parts of the state are doing well, and that the way that we do well is that we have a well-funded public system that can create public investments, schools, roads, hospitals, transportation systems in every community, not just in those that have the the money and the wealth to be able to do that. So I'm really excited to be here tonight. I will have to say that the only thing that's nerdier than being a tax policy person is being a constitutional defender, right?
That's not nerdy at all.
Yeah, and I think it is superhero business, and I'm always proud to be part of the nerd herd, and I'm always proud to be a part of you guys and the Common Cause crowd, because you're kind of our folks. So what we're here today, there's a real threat in our communities right now. And it's a threat based upon a myth. A myth, and it's an exploitation of concerns that we all have about protecting our system of government. And that the myth is that somehow if we opened up our U.S. Constitution to change, that somehow this is the right moment to do that, to improve the well-being of citizens of the and residents of the country everywhere. And it's a myth, and it's really scary. And there's a lot of people who picked up on that mantle and are really trying to use the notion that if we just had a constitutional convention, we could somehow solve the problems of money in politics. And I'm going to let you guys, I'm going to turn it over to the expert here in a minute to talk about why that's a problem. But the Colorado Fiscal Institute is involved in this effort to do more than simply stop additional calls for a constitutional convention. We, along with Common Cause and a couple of other organizations, are working hard to get Colorado's slate wiped clean of past measures that have said we want a constitutional convention. We call those measures rescission measures, and we're working very hard together and in collaboration with many organizations around the state to get the legislature to wipe the slate clean. And that's one of the reasons that we've had the privilege of bringing Professor David Super to Colorado today. David is a law professor at Georgetown University. I have to tell you that I think that being called Professor Super would just about be the best thing in the whole wide world. And after spending a good portion of the day today with David, he really is super. And somebody said, talk about a superhero. Here's a guy who really is taking time, his own time, to come across the state, to be learned in an area that's kind of obscure, right? But also to take his own time to share what he knows and help us explain to our legislators why this is a real threat, why it is important that we not only fight back things that would open the Constitution, but also wipe the slate clean. I learned today that David used to be, for 11 years, I think you said, he was the chief counsel with the Center on Budget and Policy Priorities, which is the national organization that funds a network that my organization is involved in. And so he went from just being real, normally super, to isn't he a Superman? And with that, David, if you don't mind, I'm sure you've never had those jokes before, but if you don't mind, would you share with us and this crowd your expertise in this important area of Article 5 conventions? There we go.
Thank you, Carol, and thank you all for taking time out.
Sorry.
Yes, thank you. Thank you, Carol, and thank you all for taking time out of your busy day to come here, and it's a great pleasure to see you. It's a great pleasure to see you. It's not a great pleasure to be talking about this issue because we really shouldn't be doing it. Unfortunately, this is a serious threat. and it's one that is, I think, creeping up in ways that are not widely publicized, and so I'm happy to be here and talking about it in the hopes that Colorado can play a big role in pushing this threat back. The Article 5 of the U.S. Constitution is actually quite short and doesn't say a great deal. The only part I cut off was the part saying that you can't amend the Constitution to weaken the power or to weaken states' power in the Senate or to end the slave trade before 1803. Not exactly the two provisions that I would want to entrench, but the long and the short of it is that it gives us two ways to amend the Constitution. One of them, the way that we've done 27 times, is Congress proposes an amendment, 2/3 of both chambers support an amendment, send it out to the states, and 3/4 of the states ratify it. We've done that 27 times. Some of those are good ideas, some maybe not so much, but we all know how that works. The other approach, which a lot of people don't realize is there, is that we can is that 2/3 of the states can ask Congress to call a new convention, and that convention can propose constitutional amendments. In either case, Article 5 says you should have 3/4 of the states should ratify any amendments that are done. But in the case of the convention, all Congress gets to do is say whether ratification is by the state legislature or by a special ratifying convention in the state. So in the Article 5 convention method, Congress is mostly cut out of the process. Article 5, as you noted from the brief text it has, leaves enormous questions wide open. How will the delegates be selected? One would sort of care about that. Will this be a vote of the people, or will this be lobbyists going to the state legislatures and pushing their people to be done? Maybe it will be state legislators nominating themselves, putting themselves in this position, but maybe it'll be moneyed interests saying, Larry here, no one's ever voted for Larry, but Larry would be a good delegate. Why don't you send Larry and I'll contribute to your campaign a lot. And I should just say in passing, whatever laws, not adequate laws, we have restricting the corrupting effects of money in the way we do things ordinarily, elections and legislative consideration of bills, many of those laws are not going to apply here because we've never done this before. So when you think about corruption, you think corrupt elections, corrupt legislative deliberation. You don't think corrupt constitutional convention because we don't have them. So as big the loopholes may be in dealing with our regular problems, many of those laws aren't going to apply to this at all, and the big money groups are all going to be all over that. Another set of questions, how will votes be apportioned among the delegates? One of the great democratic revolutions of the past, of the 20th century, was one person, one vote. Getting rid of the notion that rural counties with very few people in them counted as much as urban counties, and saying all of us are in a democracy, all of our votes should count equally. In the constitutional convention mode, the advocates of it are saying it should be one state, one vote. Wyoming just as important as California, and if you frankly look at the biases or the political tendencies of the smaller states, it's not representative necessarily of the rest of the country. So if we go through the Article 5 convention route, one person, one vote is basically out the door for this process. We'll put the amendments forward in a convention, which is probably one state, one vote, and it'll be ratified by states on a one state, one vote basis. And that's a pretty radical and, to my mind, undemocratic change in our political process. Other question also not answered by Article 5. What does it take to pass something? Is it going to be like Congress where you need a 2/3 majority? Is it going to be just get past the post, a squeaker is good enough? Nothing in Article 5 tells us that, and because we've never had one of these conventions before, we have no useful precedent on the subject. What about what kinds of issues will the convention consider? People proposing an Article 5 convention say, oh, it's just going to be about a balanced budget amendment, or it's just going to be about term limits, or it's just going to be about Citizens United. But there's nothing in Article 5, I showed you Article 5, that says that. Once the convention convenes, the convention controls its agenda, and it will cover whatever it wants to cover, and you can't even legitimately say it's jumped the rails when it starts considering other things, because there's nothing in Article 5 that says it's not supposed to do that. And will the convention start with the existing U.S. Constitution, or will it start over and write its own thing? The convention in Philadelphia in 1787 was told to propose amendments to the Articles of Confederation. That lasted a couple days, chucked the articles in the trash, and started fresh. As it happens, what they came up with was better, I think, than the Articles of Confederation, but there's no guarantee that that happens this time. So we could be not talking about this tweak or that tweak, but a whole new document starting from scratch. If they do choose to amend the Constitution surgically, will they be putting forward single amendments on single topics, or will they be bunching a bunch of things together, log rolling, so that if you want change A, you have to accept change B? And there are all kinds of ways, I think we know, that you can take something that has enormous populist appeal and tie it to something very troubling but sufficiently complicated that it won't resonate with a lot of the public. So, who's going to answer these questions? Those are interesting and important and pivotal questions. Who will answer it? Well, it won't be the president. No complaints from this corner. But Article 5 gives the president no role whatsoever in any part of the process of amending the Constitution. But it's also not going to be Congress. Article 5 gives Congress control over one thing and one thing only, which is whether states use conventions or their legislatures to ratify things. Congress has no authority to set the agenda for the convention, or to police it, or to say you're misbehaving, we're disbanding you. There's no authority there. There's also nothing in Article 5. Again, I showed it to you. I'm not much there to read that gives the states any authority. So you can send your delegates forward with strict instructions, but they don't have to pay any attention to them. And of course, your views and those views of other states likely will not be the same. So the state legislatures won't be doing it. The Supreme Court has said in a series of cases, the most recent is Coleman v. Miller, but there's a bunch of others before that, that the process of amending the Constitution is a political question that the federal courts may not touch. So even if you had found some secret text that's been hiding in Article 5 that somehow made some of these choices illegal, you couldn't take it to court because that's a political question. So, who is going to answer these questions? The convention itself. Once it convenes, it is the highest political body in the country, subject to control by absolutely no one.
Sounds like a plan.
How could you complain? Not surprisingly, all 27 times we've amended the Constitution, we've used the other route with Congress putting something out to the states, and the states ratifying. Congress has put a few things out that the states have said no thank you. And indeed, there have been proposals for a convention from the very beginning of the Republic. In the way they got, as you may know, the Constitution ratified was with a promise that there would be a Bill of Rights added to it. A number of states didn't want a Constitution without a Bill of Rights. Everyone said, yeah, we'll do that. In the first Congress, when they set about that, people said, hey, let's call another convention to write a Bill of Rights. And the person leading the freakout, the opposition to that, was one James Madison, who knew a little bit about constitutional conventions and said, wow, we just worked so hard to balance things in a delicate way, have a new convention, everything's on the table, everything could get destabilized, don't do it. And a lot of very thoughtful people since then have had the same view. I should also say the first Chief Justice of the United States, John Jay, also an author of some of the Federalist Papers, was very clear that a new constitutional convention was a very scary proposition. States from time to time have put forward resolutions asking Congress to call a new convention, an Article 5 convention, but we've never really gotten close to the threshold, at least not until recently. There have been a few here and a few there and so on, but it's never come to the point where a convention would actually be called. I think often because people understood the stakes were so high and what could happen was so difficult to predict. The only precedent we have is for an Article 5 convention is the 1787 convention in Philadelphia. Now, some of the proponents of an Article 5 convention said, oh yeah, states have gotten together on a number of occasions and sent delegates and they've met and everybody's behaved themselves. Well, yeah, you know, if you put $5 on the table, probably everybody will behave themselves. If you put $500,000 on the table, temptation may get the better of some people. So sure, when the whole United States Constitution isn't at stake, delegates for advisory conferences of this kind or that behave in a very proper, decorous manner. Lovely. That doesn't tell us anything about what an Article 5 convention does. A number of the advocates of this, and I don't understand why they do this, their Exhibit A for why this convention would be great, that they think is the key precedent, is something called the Peace Convention of 1861, which not a lot of people maybe know about. It was a convention held in a hotel down the block from the White House by delegates from a number of states looking for a compromise to avoid the Civil War. A number of states, both strong pro-abolition states and strong pro-slavery states, didn't send delegates, so this did not represent the whole country. A number of other delegations left midway through and said, this is crazy, we're out of here. The presiding officer, former President John Tyler, not necessarily one of my favorites, did not allow a vote on many of the packages that were put forward, very much controlled what happened, and their ultimate recommendation was to amend the Constitution so that slavery not only was constitutionally protected but could not be amended out of the Constitution without a unanimous agreement of all the states. That's not my idea of a model convention. And happily, its proposals died in a chorus of laughter when they were submitted to Congress. But again, I don't think that convention behaved well at all. Many of its proposals passed by a hair's breadth, but that certainly doesn't tell us what a much more powerful convention would do. Proponents of this say, oh, don't worry about a runaway convention. Don't worry that they'll get off the leash and do a bunch of crazy stuff because it won't get ratified. Well, I wish I could be that optimistic. But the fact is that under Article 5, there are no time limits on ratification. So even if they don't get enough states to ratify it initially, whatever package the convention comes up with will be hanging over the country and the Constitution for an indefinite period of time, waiting for a wave election or a fit of national madness to turn enough states that they can get over the threshold. When I did these presentations 3 years ago and I talked about a fit of national madness, people rolled their eyes and thought I was a bit of an alarmist. I'm hoping I don't have to sell you on the notion that this nation can have fits of national political madness today. And I would note that this threat can last a long time. The 27th Amendment was proposed to the states in 1789 and promptly ratified in 1992, more than 200 years. So if we have a constitutional convention that gets controlled by the Koch brothers and their pals, and they put out something ghastly, even if, and I'm sure everybody in this room, I would imagine, would be working hard to defeat efforts to ratify such a thing, it will be out there. It will be the disease that never goes away, threatening us, giving leverage to its proponents for an indefinite period of time. There is no provision in Article 5 or anywhere else in the Constitution for getting rid of ill-fated proposed constitutional amendments. And that, of course, is all assuming that we actually keep the ratification provisions in Article 5. Are they binding? Well, sure, except the Supreme Court won't enforce them. That's a political question. And the only precedent we have on this, the Philadelphia Convention of 1787, disregarded the ratification procedures that they operated under. They were called again to propose amendments to the Articles of Confederation. The Articles of Federation in Article 13 stated that the articles were perpetual. They bound all states until every state legislature agreed to any amendments. So you need every state to ratify. And the Philadelphia Convention says, no, we're not into that. So they put in Article 7 of the Constitution, which says that their new Constitution would apply as soon as 9 states, 2/3 of the states, ratified it. And given that I don't think we can say they have been condemned by history, everyone has, such terrible feelings about the people in the Convention of 1787, their reputation survived rather nicely, thank you. I think the new convention would feel little qualms about changing the ratification procedures going forward. Maybe we have a national referendum. Maybe we say a simple majority of the states and it binds on any of those states that do it. Maybe we say 2/3 instead of 3/4. Although 3/4 is what the requirement for new amendments, Article 7 required only 2/3 of the states then in the country to ratify. And just to be clear, it's not like the U.S. Constitution was legally okay as some sort of a side agreement to the Articles. The Articles specifically prohibited any side agreements among the states. You had to go through an amendment. Now, am I here to tell you, oh, the United States Constitution is all a fraud and we should give up on it? No, it's obviously been affected, but we have a history, the only relevant precedent of a convention feeling it knows best and it's going to change the rules and it's not going to be stuck with the rules that it came in on. And they also, even if they keep to the 38 state, the 3/4 requirement for ratification, they can make things very complicated by linking things together, some that appeal to left, some that appeal to right. That's not unprecedented. We've got a bunch of amendments already that include a lot of fairly disparate topics. I put 4 examples up here. The Fifth Amendment's got a lot of criminal justice stuff, but then it's got a general due process clause, and it's got taking private property for public use, which has nothing to do with criminal justice at all. The 14th Amendment has more stuff in it than I almost can count. Public debt, privileges and immunities, the definition of citizenship, and so on.
Before you get too much further, I just had a quick question about 2 slides back.
Yeah, there?
One more. The first 2 points on there, it's no different than with Congress, correct? Like, Congress is potential for a wave 38 states and the being proposed could be amended later?
Yeah, I mean, the 27th Amendment was a congressionally proposed amendment. Every amendment we've had has been congressionally proposed. So yes, when Congress puts an amendment out there, it can linger and get picked up later. There are a few old amendments that Congress put out there that are frankly really, really bad and could be, in theory, adopted now. I'm hoping they're so transparently bad that no one would support them these days. But yes, that could theoretically happen. I'm not doing this right at all. So you can have, again, a compound or log-rolled amendment. I adore the 14th Amendment. I think these were, lovely things for them to do. But it was sort of a general, all the stuff on our mind, or most of the stuff on our mind kind of amendment. And a Article 5 convention could do that as well. What do I mean? Well, I just threw together a few examples. You've probably got better ideas. But could you get 38 states to ratify something that created a national security exception to the First Amendment, but limited the Second Amendment? I don't know. There's some people that feel much more strongly about one of those issues than the other, would be willing to swallow the one they don't like to get the one they do like. Override Citizens United, but cap federal spending at levels that force the cancellation of a lot of important domestic programs. Would that go? I don't know. How about revising the Electoral College, declaring this country a Christian nation, and prohibiting affirmative action? Would that fly? I don't know. I think it could. Or a balanced budget requirement for the federal government and repealing the 10th Amendment's protection of state powers. Would that go or not? And you can come up with your own combinations, and I think there's every reason to think that the big money interests that have been pushing and spending just stunning amounts of money on this Article 5 drive will come up with stuff like this. They will have ample polling and focus groups about what sort of combination of amendments would get through and get ratified. And just for an example of some of the stuff that we can be thinking about, the First Amendment almost certainly is going to be front and center. And I just collected here a number of complaints about current First Amendment doctrine, a number of which I will confess I share. President Trump thinks that journalists that are writing all those bad stories about him need to face some consequences. Justice Thomas recently said he doesn't think the original intent of the Constitution supports New York Times versus Sullivan, which is the protection against defamation suits for journalists by politicians who don't like what the journalists write. Whenever journalists write stories about how the evidence for the Iraq War was manufactured, or some of anti-terrorism campaigns are on flimsy to no grounds, people say they're traitors, they're fifth column. There certainly are attacks on separation of church and state, suggesting that we should have more subsidies for religious institutions of one kind or another. And then on the liberal side, there are concerns about the campaign finance cases, about the protection of commercial speech, or some of the public forum cases skewing expression in favor of those who own more property than those who have to do it in the public. So you can certainly imagine an effort to rewrite the First Amendment, but I don't want to imagine that because it scares me. Leading figures across the political spectrum have been very skeptical about a new Article 5 convention. I mentioned James Madison and John Jay. I don't quite know where to put them on the political spectrum, but Arthur Goldberg was a leading member of the Warren Court, and he points out that a runaway convention is a huge risk, and that moneyed special interests would likely dominate one and put their self-interest ahead of the national interest. It's part of a long, really terrific op-ed he wrote in the Miami Herald, where he also pointed out that the Philadelphia Convention in 1787 violated pretty much every rule that was put on it, by the states and by the Articles of Confederation. There's no reason to think a new convention wouldn't do the same. On the other end of the spectrum, Chief Justice Berger said that a constitutional convention would be a free-for-all of special interest groups, and really made arguments about money and politics that could just as easily have been written by someone from Common Cause. Whatever you could say about his opinions in his views on an Article 5 convention, he absolutely got it. And then Justice Scalia, I certainly would not want a constitutional convention. Whoa! What comes out of that? Got that right. This is the position that we find ourselves in. I actually believe that had the November election not flipped the House of Representatives, that we would currently be seeing Speaker McCarthy and Majority Leader McConnell claiming that they already have 34 states that have proposed a convention. They used to have a scorecard in which they claimed to have 28 states, which is still pretty uncomfortably close to the threshold of 34. As it stands right now, they could get to 33 states without a single Democratic vote, with, in other words, with all red-on-red states. They could get to 33, and they take 1 or 2 Democratic votes in some other state to get to 34. But they've actually, their alleged experts have been putting out opinions saying, oh, you can aggregate things that actually don't say the same thing. So we can take some really old resolutions from states that say nothing about a balanced budget amendment or limiting federal power and add that to the total. There's also some reason to think that they'll try to take some of the resolutions that Wolfpack has been persuading states to adopt and say, see, these states want a convention too, let's have that together. And again, that question as to whether the threshold of 34 has been met is not going to be looked at by the Supreme Court. Not even this Supreme Court. It's going to be entirely up to Congress. I don't think Speaker Pelosi's going to go for this sort of thing, but she won't be Speaker forever. And I have no doubt that given the enormous amount of right-wing money that has been poured into this, that Majority Leader McConnell would play along if he was pushed to do this, and I'm sure the House Republican leadership would as well. For that reason, I think it is extremely important for states that have resolutions on their books calling for a constitutional convention to rescind those, to wipe the slate clean, and not allow themselves to be counted under anybody's fuzzy math, creative arithmetic, or whatever towards the number of 34, to make it absolutely impossible for anyone with good faith to say that Colorado wants any part of this. Delaware, Maryland, Nevada, and New Mexico over the last few years have gotten rid of old calls for convention that they had on the books, so that make sure that they wouldn't be counted. And I know there's some other states, in Colorado certainly would be a prominent one, where it would be great to see further action in this regard. One last thought to leave you with, to cheer you with. Yeah, I was not the inspirational speaker. That person got lost. As bad as one Article 5 convention is, that's probably not what we're talking about here, because if we have one, very likely a key part of it would be a fiscal straitjacket for the federal government. Next time we have a recession, that means when revenues go down and claimants for unemployment and food stamps go up, we'll have to raise taxes or cut spending in the middle of a recession, making it worse and worse and worse. And that will lead to calls for another Article 5 convention, because you don't think the members of Congress will want their fingerprints on getting rid of an amendment that a convention process just added. They'll say, well, let's have another convention. So even if the Bill of Rights is fortunate enough to survive the first Article 5 convention, there likely will be a second. Once we get accustomed to this, this will be something you do when you win an election big, and we will have yet another political football, the most important possible political football, added to our already divisive politics. And another way of thinking about this is, do you want to get rid of a constitution that was written by a country that elected George Washington and replace it with a constitution written by a country that elected Donald J. Trump?
I have two questions. The first question is, so God forbid we did have a convention, so who pays for all those costs? And then the second question is, Canada seemed to have held a reasonable constitution convention, and they seem to be living under it okay. So other than being totally crazy on our side of the border, why wouldn't that work here?
In terms of the cost of a convention itself, the public costs, that presumably would be paid for by Congress. It would not be cheap, but I don't think it would be staggeringly expensive compared to some of the things that we seem to want to spend money on. I imagine you could hold a constitutional convention for maybe half an aircraft carrier's worth or something like that. That is true. But however, there are all sorts of side costs, and in particular influencing who are the delegates and the amount of money that ALEC, the American Legislative Exchange Council, perhaps best known for their championing stand your ground laws, the amount of money ALEC has been channeling into this. As you may know, their conferences are sort of fundraising, meet-up, pairing things for big donors and right-wing activists, and they have been throwing tons of money at the groups that are promoting an Article 5 convention. And one imagines that if they actually get one, they will spend far, far more than that on making sure that they get just the right delegates, on staffing those delegates, on messaging out of it, and so on, in a way that will actually make our current politics pristine. In terms of Canada, I think it's my knowledge of Canadian constitutional law is not what it ought to be. But I will say that they have what we really don't, or they had what we really don't, which is a fairly strong tradition of individual liberty protections outside of the text of a constitution. They had something that was sort of a constitution before that. They didn't have something like the Bill of Rights at stake. So I think their stakes were a little bit low, but also your other point is right. I think the political culture there is a little bit more mature. There is some notion also there that the country could easily blow apart if they did it wrong. First Quebec, but also the Maritimes and maybe the oil states or provinces out west. There were some constraints there. I think this process could blow this country apart as well. But given that we had a civil war over secession, that's not something that most people, or at least most people who are not governor of Texas, think about.
Yeah, I have a question. Everybody in this room, and probably mostly in this state, have strong negative feelings towards Mr. Trump. What is the feeling in Washington?
The question was, people in this room and in this state have negative feelings about the president. What do people in Washington think? I'm reluctant to take on the role of the arbiter of views in Washington, but I think the general sense is that he has enormous power with the Republican base, and that almost all Republican elected officials on the one hand have contempt for him, but on the other hand have fear for him. and are not prepared to cross him publicly. And I think that at the moment his power over the Republican Party is pretty absolute.
So then my follow-up question is, why do they feel powerless involving this man who's just a narcissist?
The question is, why do Republicans feel powerless? Because relatively few people vote in primaries, and that they believe he can turn out people to throw them out of office. And he's done that on a number of occasions to a number of people, many of whom then turned around and lost the general election. His threat to primary people, I think, given low turnout in primaries, has been seen as a very, very scary thing. And even if you're not one of those people who thinks you might get primaried, it's a whole lot more fun to be in the majority than in the minority. And if there's an open break of the party with him and it splits with him supporting primary opponents who can't win general elections, they could lose their majority in the Senate, they could stay in the minority in the House. So I think that dynamic keeps him strong.
This gentleman's been waiting
I'm
here.
sorry.
What is the history of the 28 current calls for convention? Like, in another way, what saved us from this happening during the Ryan McConnell leadership period?
I think there was the question was, why didn't Ryan and McConnell do this?
Or like, when did those 28 calls come about?
If I may be off by one in my numbers here, so I apologize, but 13 of those are old. They're from the late 70s and early 80s. And the rest of those have come about in the last decade or so. I think the supporters of this believed they could just get 34 the honest way until the just past November election. They could have actually gotten to, I think, 35 or 36 without a single Democratic vote. And when you're a right-wing machine, and the states that are holding you back are South Carolina, Idaho, and Montana, you feel fairly good about getting there, and so they wanted to keep their credibility. What we saw last summer, after they got beat in Montana and Idaho and stalled in some other states they thought they would take, is they started coming out with more and more bizarre theories about how to count states and aggregate states together, but I think they started that too late. Some important people wrote to McConnell and Ryan on the run-up to the election, but by then I think it was just too late. If they had recognized that they couldn't get the rest of the 34 states honestly earlier, I think this could already have happened. So we are beneficiaries of their hubris, and I'll take it.
Thank you.
Absolutely.
This gentleman here was next.
I'm sorry. Oh, yeah. Why don't you keep the cue? Thank you.
Hi. To get back on track to what we're talking about, rather than we hate this or we hate that, is there a way, outside of the Constitutional Convention, of constructing rules or correcting the omissions of Article 5?
There are places in the Constitution, most obviously Article 1, but also the 14th Amendment, Section 5, and a number of other places that give Congress legislative power. There is nothing in Article 5 about that, and the point of the Article 5 convention process, as it evolved in the Constitutional Convention of 1787, was to give the states an emergency bypass if Congress stopped holding elections or whatever, analogous to the Long Parliament in England. And so I think there's a pretty compelling argument that Congress was not empowered to act in this area. The legal argument, when they say one thing, they imply the negation of the others, because they give Congress these two narrow powers to set the method of ratification and to propose amendments themselves, but that implies that they can't set rules. There are some conservatives who I disagree with but respect, who suggest that we should first have Congress promulgate and the states ratify an amendment to Article 5 that would change the process and then go forward and do this process. I really am afraid of an Article 5 convention, even if we had some rules, but that is an approach with some integrity. That's not an approach that the Koch brothers and their various allies have shown the slightest bit of interest in.
Yeah, well, be that point, I think that if something like that were to happen, the first thing that I would personally like to see is an amendment stating that you can't change existing amendments.
Huh?
I think that would be a hard thing to do. We have changed existing amendments a few times, repealing prohibition, changing the presidential succession, and a lot of people would point to those as things that are valuable. And I think,
as in discarding.
yeah.
You know, you mentioned changes to the first.
Yeah.
All right. There have already been unofficial changes to the first. We've had free speech zones since, I can't remember when there was a World Banking Convention that happened in Seattle. I think it was the first time I heard about it.
Yeah. No, I mean, there certainly are ways to do constitutional change. There is the congressionally initiated process, and frankly, and then you sort of alluded to this, the Supreme Court is engaged in constitutional change, you can call it amendment if you like, a great deal of the time. If you look at what is required to go through an Article 5 convention, versus what is required to go through congressionally promoted amendments, versus what is required to elect a president and 50 senators who will confirm Supreme Court nominees with a different view, the presidential and Senate election process is infinitely easier, and in my view, that is the way of getting rid of reprehensible decisions like Citizens United and Buckley versus Vallejo.
Thank you.
I guess my observation on this is, I wonder if, I believe it was Thomas Jefferson that said we need a convention every 20 years, or some sort of an overhaul every 20, 25 years. And I'm wondering if we had done that, you know, every 20, 25 years go through and look at this and do something different, whether or not that would help or hinder. The thing, also the other observation in the Philadelphia situation was this was new. You know, they had the Articles of Confederation, and okay, they didn't have 250 odd years of history behind that to toss out. You know, they just had the, what, 10, 12, 13 years of the Articles of Confederation to toss out. We've got 250 odd years of history behind this.
I mean, in terms of Jefferson, Jefferson wasn't in Philadelphia, and I'm not sure quite appreciated all the mechanics and all the mischief in a convention. Jefferson had some really lovely ideas and some really awful ideas. As I don't know how much people have read about him. Well, I'm not going to start because I wouldn't stop about that. But the fact is, we haven't. I think if we did have a periodic overhaul process, we might have evolved a notion where those periodic reviews couldn't touch the Bill of Rights and the 14th Amendment, 13th, 15th Amendment, so on, and come up with some way of constraining it. I agree Article 5 is probably a creature of their lack of experience, that it is what we have, and the dangers it creates are there.
Okay, so we're going to take about 3 more questions. So you've been waiting 1, 2, 3. Can we do that?
From what I have seen, read a little bit, Article 5 has, at least the threat of an Article 5 has been used in like 15 of the 27 amendments. And taking it off the table seems like not a good idea.
Well, I don't think I would agree with the math there. I mean, people may well have said we'll go through a convention at one point or another. The only example where I think there was a serious broad movement in this regard that I'm aware of was regarding the popular election of United States senators. And I guess I would just say that it isn't much of a threat if something is going to do harm to you. It's not obvious to me why Congress would be afraid of an Article 5 convention and do the right thing. What's driving their behavior under all of these circumstances is significantly the effects of big money. And the Koch brothers are not only okay with an Article 5 convention, unthreatened by one, but spending profusely to get one.
I just wanted to stand and make my comments, and thank you very, very much for being here tonight. If I can just make a comment real quick. These are somber times for me as a father and for our nation. And I drove down here from Colorado Springs to be here tonight with you. A few months ago, President Trump asked, what is the point of life anyway? He asked that question. And in 1993, I stood in front of President Bush and received the 897th point of life at the White House. And I have to tell you that what we are facing right now is not only scary, but it is an erosion of the principles of our democracy that were founded long before the elected officials that are sitting in office right now.
Yes.
And if those fundamentals were true then I believe they're true now. And so I'm asking all of you tonight, while we sleep, these politicians are at work. They're devising schemes and strategies to change how we fundamentally relate to each other in a democracy. And so, as a father and as a citizen, I am here to say that we are the points of light in this nation. And that at any point in time that we are together and we are collective, we prove that darkness can't reign on democracy and the freedom of what our country was founded on. And so I'm here tonight, honestly, just for my son. He's 14 years old. And he asked me where I was going tonight, and I said I have an important meeting to go to. And he said, what is that meeting about, Dad? And I said, it's about you. This is about the future of our kids and what they will inherit in our country. And I don't want to see any portion of it going backwards. And the model that we ought to have leaving here tonight should be always forward and nothing less. Thank you.
Thank you so much for those words. That's amazing. Thank you. At the beginning of the session, we talked about rescinding Colorado's call to hold a constitutional convention or approving whatever form that was in. I heard, I can't even remember the source, probably NPR, a bunch of talking head sorts of things, and someone saying, you know, states have rescinded this, but they don't know that that is that you can really that it would be valid. That you know, they could say yes. In 1970 we wanted this and we don't anymore.
Yeah, I mean, Colorado, I believe, has 6 currently active calls for constitutional convention, the earliest from I think 1905, the latest from 1992, on raising a variety of issues, popular election of senators, and which is obviously already in the Constitution, so that's been taken care of, and a number of other things that may or may not have been good ideas at the time or not. So we're talking about cleaning up some fairly old stuff. In terms of whether a state can rescind this or not, again, the Supreme Court has refused to wade in. They talked about rescissions of ratifications of amendments, which is not the same but arguably analogous, and said we will not opine on that. That's a matter for the political process, not us. I would say that a lot of this is about shame, and shame is not gone from our country, but it's the capacity is shrinking a lot. But I think if they got to 34 states, by counting states that had rescinded, that many people would hold them up to ridicule. That being said, I will say that one of the person who the proponents most cite as their expert in Article 5 wrote an article last summer in which he said we shouldn't count most state rescissions because the states are making mistakes. And if you rescind your calls, I'm sure he will tell you that you are mistaken, you blew it, and you should be ignored. If they wanted to go national with that, there's nothing we can do to stop them, but I think the goal is to make it as blatant a coup d'etat, as blatant a disregard of the Constitution as possible. Aggregating disparate resolutions is, I think, offensive and shows an anti-democratic spirit, but disregarding rescissions would take it to a whole nother level, and I think that's what animated the people in Delaware and Maryland and Nevada and New Mexico.
This gentleman of different ability, I believe you were raising your hand but couldn't get it as high.
That's why they weren't seeing me.
I just wanted to give him the opportunity to speak.
Thank you. That's why they weren't seeing me. Thank you. So, I just wanted to go sort of back to the beginning, sort of about this whole process. All of the, it seems like most of the very scary things that happen with Article 5 conventions wouldn't apply to the traditional 27 amendments that we did through legislative work and ratification by the states. But clearly the fit of madness routine seems like it would still apply. Are we saying that should also be off the table, or are we saying that is in fact the way we should go about moving forward with some of these concerns, like Citizens United, etc.? Or are we sort of stuck with, or in your mind, are we best stuck with what we have?
No, I would not want to produce that I think are highly problematic and deserve attention. Citizens United would be one, although I think since that was a 5-4 Supreme Court decision, a president who will appoint responsible justices and enough senators that Mitch McConnell can't refuse to hold hearings would be a simpler and better solution to that problem. I guess what I would say though is that the beauty of the traditional process is one person, one vote. If you don't go through the convention route, you have to go through the House of Representatives, which is elected on a one-person, one-vote basis. It's, plenty of bad things to say about the House. I'm not here to sing its praises, but we, even when we have collective madness, we generally don't have 2/3 of the United States House of Representatives being irresponsible and awful.
Right.
Thank you.
Denver for coming to Colorado and speaking not only at election, but also coming to our happy hour. So he's done 2 presentations today. So thank you. Thank you. Also, thank you to the Colorado Fiscal Institute for co-hosting. One thing I failed to do is invite anyone who would like to become a member of Common Cause. Please feel free to see me at any time. I would also like to invite you back next month, April 4th. As many of you know, I'm pretty sure I know this crowd knows, that there is an election coming in Denver. And we are going to host a forum for our clerk and recorder's office. And I've been able to get all 4 candidates to agree to come, answer questions, and let you know where they stand on that office. So thank you for coming out. Yes.
I have a question. Does Common Cause have a bill that they want to present to the state legislature? And if so, how do we refer to that, or who do they have sponsoring that? About the rescission.
Open that up to our policy person here.
Is there a rescission?
We're looking up something else.
I was Googling. So the question is, where are we on rescission?
Yes.
Is there a process in place?
So there is a process in place. We are working with members of the legislature now to have a memorial, which is the process that it's something different than a resolution, right? That would be the vehicle. A joint memorial would be the vehicle for rescinding the measures that we've passed that we've adopted in the past. Where we are is the legislature is taking on a lot of big issues this year. And there is concern with taking on another big issue. And so I think what we need to do, and I think there's support generally for the idea, the question is, can we do it this year? I think it would be great if everybody would reach out to Lois Core. You all know Lois? If you would reach out to Lois and say, hey, this would be a really great thing for us to do. And also reach out to the Speaker of the House and say that we would really appreciate, we think that this would be a really important way to kind of wipe the slate clean. And regardless of what other things we might want to do in the future, that would be great. And you can take your own positions on those. But let's clear the process from the things that literally are from 1901. 1905 to 1992. So we are not the state that we were then. So I think the process is that would take a resolution in both houses. Would not have to be signed by the governor. I don't know that he would care one way or another, or what his position would be.
It's only a resolution.
Actually, you can do a resolution, but the way it's traditionally done is something called a memorial.
Right.
We memorialize Congress. That's right. That's
So
right.
could you remind me, I'm sorry, but who is the Speaker of the House?
The Speaker of the House is K.C. Becker.
Casey Becker.
K.C. Becker.
And why Lois Court? Yeah.
Because she's
Because I think she is our best choice in the Senate for somebody who would be excited and interested in doing that, because she is a defender of the Constitution.
I've spoken with Lois Court, and unfortunately, she seems to believe that the restriction that says this only pertains to blah 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 is effective. So she needs to hear that does not protect us. So I approached her, and she seemed to think there wasn't a problem because it's only if it triggers one narrow thing.
Yeah.
I think that, well, I will just say this. We have an opportunity to present where Professor Super will be talking with Senator Court tomorrow. And, I think this presentation is very persuasive. I too speak with Senator Court on a regular basis. I think she is particularly concerned about the balanced budget amendment, as well as some of the other amendments that we have that we are on record for. And so I'm hoping that she might be one who's willing to say, let's just clear the slate. Again, going forward is a different set of issues,
right,
that we can all make our arguments on one side or another. But I think that she is supportive of the idea of wiping the slate. slate clean.
So we should wait until after tomorrow.
I would
to
call her
contact
next week.
Yeah.
Plus, the other thing I would say about Senator Court is that she is the chairman of the Senate Finance Committee, which convened a hearing today on the oil and gas regulation. They were in testimony from about 10 o'clock in the morning until about 5 o'clock this afternoon. So you might want to give Lois the weekend in order to take a deep breath before we started to call her.
Any results
All in
from
my
the-
district on Saturday, so I plan to see her.
Well then, there we go. See, she's one that has a bundle of energy.
Yeah. Any results from the hearing?
I don't know if they took a vote or not. I'm sorry, it's funny because I saw, we had one of our folks was down testifying, and I didn't ask what happened with the committee vote. I'm sorry that I didn't ask.
Just a point of clarification, so, you know, in the case of Colorado, they said we'd like an Article 5 constitutional amendment to address a balanced budget amendment. Is
That's
that,
right.
you know, so it was.
In 1978, that's what happened, yes, and then yes, exactly.
Okay,
That
so
was
it
adopted.
wasn't, we just want an Article 5 convention, period, the end, we don't care what happens. It was for specific.
In all of the cases of the calls in the past, they were for specific purposes. That is correct. That is correct. So, one of the things, yes.
It'd be helpful if we all find
Yeah, you guys want to sign a piece of paper that I can hand to Lois when we see her? That'd be great. We'd love that. Can I say one other thing? Was I right? Yeah, right. So I just wanted to note that Amanda Gonzalez, the executive director of Common Cause, isn't here tonight.
Right.
And rather than anybody thinking she doesn't care about you or that she's not here because it's important, she has been nominated to be a 40 under 40 by the Denver Business Journal, and she was received that award. And so we are thrilled to be able to celebrate that Amanda and her accomplishments and the recognition. She would be too. She was embarrassed to say that to everybody, so she didn't tell you that's why she's not here. But I'm not embarrassed to tell you about it. And so next time you see Amanda, congratulate her on the well-deserved recognition as one of the 40 under 40 in our community. Any other comments or questions? Thank you so much for being here, and thank you so much for your advocacy around this really important issue.